In a Florida divorce, a business is an asset like any other asset that's been accrued during the course of the marriage, so long as the business was started during the marriage. So if there's a business at play in your divorce case, there's extra consideration and extra factors that needs to be done to make sure it's done properly, including additional discovery, additional depositions potentially, additional interrogatories. All of these things can help complicate a divorce that's already complex and emotionally challenging. So in a divorce case in Florida, if there is a business at issue, typically what I have my clients do and what I advocate for is a formal business valuation that's done by a licensed professional that can help essentially evaluate the business so you know what actually might be at play for equitable distribution purposes. This is an additional cost and it is not required, but it does help guide the court and guide myself when I'm preparing for mediation and preparing for trial so I can do the equitable distribution properly and make sure it's done appropriately. In a Florida divorce, typically if there's a prenup in existence, the prenup basically lays down the ground rules for the divorce. If a business was contemplated in the prenup, that will also protect the business and essentially protect the parties from each other to make sure they're not fighting over a business they've already agreed to prior in terms of how it should be divided at the end of the day. The other thing that you can do if you're a business owner is and your partner is an equal owner of the business, you can set out in your incorporation documents what happens when a divorce occurs in terms of each ownership share for each partner. In a Florida divorce, business debt is still a part of equitable distribution, especially if the business was started during the marriage. So it is a part of equitable distribution, as is everything else, which means that we do additional discovery, we ask for business bank records, and we try to figure out what debt was accrued for that business during the divorce that each partner or each party may have a liability for. And that's essentially included in your equitable distribution worksheet. In a Florida divorce, if a business was in existence prior to the marriage, that's typically considered a premarital asset. So if there's any liabilities associated with that business that occurred prior to the marriage, it won't be at issue in the divorce case unless it's been what we called commingled, meaning the party who owns the business would have had taken some action to commingle the business and make it essentially a marital asset. This can include transferring assets that would have already been considered premarital business assets to your spouse during the course of your marriage, and that can all mean that this has been commingled and can potentially be up for dispute during equitable distribution. If you have any questions regarding business ownership and how it might impact your divorce, please contact us at Cooper & Cooper PA so that we can conduct a free 30-minute consultation to discuss your business during the divorce process.